to throw the phrase monetary policy, economic policy, I'm sure it was not to frighten the court into looking into the matter. These words cannot stop the court from looking into the matter. And to say you're not experts. Are we experts? We're not arguing here. We are not experts either. But we gather material and place it before you.
Except Mr. Chidambaram.
Yes. Everyone?
Except Mr. Chidambaram.
I'm not an expert.
But the Evidence Act says court is an expert's expert.
Therefore, my lord, to frighten a court by saying this is expert, experts have looked into it. The lawyers and courts educate themselves on the subject and apply their mind. How do your lordship decide patent cases? Are you engineers? Are you chemical engineers? Are you microbiologists? Yet you decide patent cases. How do you decide trademark cases? Therefore, my lord, to say that this is experts have looked into it, you can't even ask us. I think, my lord, it's an utterly futile argument today. Therefore, my lord, please don't be intimidated, and I'm sure your lordships are not, by the words monetary policy and economic policy. This is a simple act of declaring currency as no longer legal tender. There is a decision. There is a decision-making process. Your lordships can examine the decision-making process, and your lordships can even examine the decision if it is manifestly arbitrary and absurd. This entire case is about decision-making process. We know the decision is a fait accompli now. We know that the decision cannot be reversed. But we want the law to be laid down. What is the decision-making process in 26.2? We can't read only 26.2 and come to a theoretical conclusion as long as there is a recommendation, which is according to the RBI, the penultimate step, and the final step is the notification. Suppose, Miller, this 24 hours was reduced to 24 minutes. Would your lordship still uphold it? Suppose it is 24 minutes. The RBI governor, our RBI board meets, and then the governor sends it, and then the cabinet is ready, and after 24 minutes the decision is made. Would it be still upheld under 26.2? Look at the enormity of the consequences. Can a decision of this nature be taken? Having taken the decision, why are they fighting shy of telling your lordships how the decision was taken? Your lordships have repeatedly said we can't question the wisdom of the decision, but you can certainly question the decision-making process. At least if the decision-making process has been fair, it's possible that in most decision-making processes which are fair, the decision will be fair. You can still follow a decision-making process which is fair and still come to a... Einstein said, insanity is doing the same thing over and over and again and expecting a different result. In 1946, governor said black money and fake currency cannot be abolished by demonetization. In 1978, governor said this cannot be done by this method of demonetization. In fact, he used the word unprecedented. There is no case, no example of demonetization in such circumstances. The only two circumstances are when hyperinflation and where the currency has become worthless, or the very old currency, which is no longer used or usable. There is no other example of demonetization. And having taken that grave step, why are they fighting shy of this? If they are able to defend the decision as they have done over the last 2 days, why can't they defend the decision-making process by placing the documents before your lordship? They should be able to confidently defend not only the decision, but the decision-making process. But I submit, Miller, in the absence of these documents, what is this? No, we come to that. Now, that is my submission on the third.
Chidambaram,
Yes.
see that you said there could only be two objectives about the demonetization. In fact, we have taken out a list of countries which have experimented demonetization or as well as reasons from 1873.
Yes.
There are other reasons
Up to Miller, up to, if I may ask.
up to 2016
Oh.
from 1873. 1873 in USA, the silver was, silver was said no longer valid. Then 1923, Germany, the objective was stated to be to prevent inflation. 1969, USA, they said to resist black money.
Yes.
So,
No, what did they demonetize? No, that's the question.
no, they demonetized the currency. See, that led to the, in fact, American banking system. Then 1971 UK.
Your Lordship may pardon me. I was in the US at that time. What they may have demonetized some high value currency.
That's right.
Which is very
No, the objective
low in
cannot be
circulation.
limited to two, is what I'm saying.
No,
Objective is not necessarily limited to two.
inflation. I said so. Hyperinflation is one ground to
No,
demonetize.
black money is also another ground. In fact, some of the countries like Ghana, etc., the Myanmar,
Look, those
They
are
have-
certainly not Zimbabwe and
just to say on the
Argentina,
academic,
Myanmar.
on the
Certainly not
academic
like-
side, to say that there could only be two
No,
objectives, may not be
maybe,
strict.
to the best of my knowledge, these are the two objectives. But if there is hyperinflation, clear. In fact, most demonetizations are based on hyperinflation, where the currency goes to a million, 1 rupee becomes effectively worth less than a million rupees can buy you a cup of tea. You have to demonetize the old currencies and issue new currencies. Post-war, Germany demonetized its currency and issued fresh currency because they didn't want the Nazi regime currency, which apparently had been
Anti-Semitic.
wholesale counterfeited, and all kinds of people were flushing in currency into the system. Both the then finance minister, chancellor, and the finance minister, Erhard, demonetized the currency and issued fresh currency. I'm not saying they can't be, maybe there was, but these are the two examples. But if they are confident of defending the decision, why can't they defend the decision-making process? Let us see what was considered, what was decided, what was recommended. Well,
See, in fact-
close my
In
submission.
fact, the learned Attorney General
Yes,
submitted that the central government cannot look at it in a very myopic way.
yes.
There are so many considerations, and therefore it may not be only to the two reasons which you submitted. There is security of the state, the economy, to be rid of black money. There are so many, terror funding. Therefore, is it not possible for the central government to initiate a proposal of demonetization?
Great response.
Why should it be only
Three objectives.
RBI?
Three objectives are actually two. There are actually two objectives. 1A, 1B, and 2. 1A was fake currency, and 1B is fake currencies financing terrorism. So it's really one objective. They put it as two. Let's take it as 2 or 1. Fake currency and fake currency financing terrorism. Number 2 was to eliminate black money. These are the two objectives. These two objectives were opined by two governors as not achievable through demonetization. That is history. They want to do it again. Fine. They can share information. They can share information. Let us see what information was shared. And what did the governor and the RBI board take into consideration? Surely, my lord, if RBI board was aware of the currency in circulation, etc., etc., surely the RBI governor must be fully aware of the fact that in 1946 and 1978, the RBI opposed demonetization and they resorted to the plenary power of legislation. And surely the RBI, history of RBI is published by the RBI. They must be deemed to know that also. And there have been only 2 demonetization prior to this one, at least in recent history. We don't know about 1800s or so, 1946 and 1978. They must be deemed to know that. So if they recommended it. What did they recommend? I don't know, Mira. We are still in the dark. We are still looking for a black cat in a dark room. Whether the black cat exists or it doesn't exist, we don't know. So I would implore your lordships, it would be not doing justice to the petitioners who are before your lordships, unless your lordships see these documents and satisfy yourselves that the decision-making process was fair and not arbitrary, and they took into account relevant considerations and eschewed irrelevant considerations.
In my note, I.
Please wait, please wait, please wait, please wait.
That is my third proposition. Namala, there was some reference to monetary policy. But I don't want to convert this exercise into a debate on monetary policy. But the best of my knowledge, and I will support it, demonetization has nothing to do with monetary policy. I have just given a compilation. With your lordships, just look at the thin compilation. I'm not given it yet. Just see that compilation. And I have to explain the 2017 Act and then the relief. And I'll be done. This one. But I'll come to 1 and 2 later. Just look at the item 3. This is Milord from former Governor Rangarajan's recently released book, Forks in the Road. He's by universally considered one of the topmost monetary economists in the country. Now, this is from the Forks in the Road. Now, kindly see what monetary policy is, and Justice Ramasubramaniam in his judgment also deals with this subject, and in fact points out to a chapter in the RBI Act on monetary policy. Nothing to do with demonetization. Kindly see this time. So, to throw the phrase monetary policy, economic policy, I'm sure it was not to frighten the court into looking into the matter. These words cannot stop the court from looking into the matter. And to say you are not experts. Are we experts? We're not arguing here. We are not experts either. But we gather material and place it before you.
Except Mr. Chidambaram.
Yes. Everyone?
Except Mr. Chidambaram.
I'm not an expert.
But the Evidence Act says court is an expert's expert.
Therefore, Miller, to frighten a court by saying this is expert, experts have looked into it. The lawyers and courts educate themselves on the subject and apply their mind. How do you lordship decide patent cases? Are you engineers? Are you chemical engineers? Are you microbiologists? Yet you decide patent cases. How do you decide trademark cases? Therefore, my lord, to say that this is experts have looked into it, you can't even ask us. I think, my lord, it's an utterly futile argument today. Cases will involve technology. The crypto exchange, the bench which heard that did a lot of homework. And I'm a little worried. I'm fine that Justice Ramasubramaniam has done homework on demonetization also. So I'm a little worried whether I'll be tripped in my argument. Therefore, to say economic policy, monetary policy, all that, my lord, is irrelevant in this day and age. Cases will become more complex. Cases will involve high technology. And you have to decide. Kindly look at this one. The stance of monetary policy in any year. Now, the broad objectives of monetary policy have remained the same over the years. They are to ensure adequate expansion in credit and to moderate monetary expansion to maintain a reasonable degree of price stability. In fact, Milord, monetary policy is only concerned with price stability. Price stability will depend upon whether more money is chasing goods or the less money is chasing goods. That's one of the factors. But this is the objective. Then next one. The objective of price stability, however, is not an end in itself. It's a means to achieving growth. Except in a very short period, there cannot really be a conflict between the objectives of price stability and growth. Even on considerations of social justice, inflation control is important as inflation hurts the poorest segments of society. The 1994-95 report explained the multiple factors influencing inflation and the role of monetary policy. I'm not reading all that. Now kindly color over the page. Kindly come to page 15, running page 15. Getting back to the objective of monetary policy and the mandate for RBI, report added, autonomy or independence of central banks is an issue that is being debated widely over. Autonomy has many dimensions, of which the most important relates to the conduct of monetary policy. History shows that successful monetary policy requires not only a high degree of operational freedom for central banks, but also a clear enunciation of the dominant objective of policy. In industrially advanced countries, inflation control has become the dominant, if not the only objective of monetary policy. With the discontinuation of automatic monetization of central government deficit, a major step towards functional autonomy has already been taken. However, there has to be a general consensus on the need to keep the inflation rate around a certain level. Let's skip all that. Kindly come to page 12, last three pages. In any monetary policy framework, a key ingredient is the enunciation of its objectives, as its actions are guided foremost by the objectives. A recurring question in this context is whether monetary policy should be concerned with all the goals of economic policy. The issue of objective is important because of the need to provide clear guidance. Indeed, this aspect will assume added significance in the context of the increasing stress on autonomy of central banks. Then kindly come to page 19. In talking of the objectives of monetary policy in India, I had said on an earlier occasion, in a broad sense, the objectives of monetary policy can be no different from the overall objectives of economic policy. The broad objectives have been, one, to maintain a reasonable degree of price stability and to help accelerate the rate of economic growth. Nothing to do with fake currency. Fake currency will always be there. Even today, it's there. Black money will always be there as long as people hide their incomes and don't pay tax. It will be black money. And as my Lord Justice Nazir said, terrorism can be financed by both by fake currency as well as genuine currency. These have never, demonetization has never been considered a part of monetary policy. Monetary policy is only concerned with price stability. Now some countries add the other objective. US employment is added. In India, right, price stability along with supporting growth. That is the objective. Therefore, Milord, please don't be intimidated, and I'm sure your lordships are not, by the words monetary policy and economic policy. This is a simple act of declaring currency as no longer legal tender. There is a decision-making process. Your lordships can examine the decision-making process, and your lordships can even examine the decision if it is manifestly arbitrary and absurd. I'm not saying it's manifestly arbitrary. I'm only saying please examine the decision-making process. If that decision-making process is flawed, then the decision must go. Well, the next submission is kindly see two judgments. How this matter relating to economic policy have been observed, that have been approached by the courts. First, take, my Lord, the internet judgment itself. There also, it was said it's economic policy. RBI was involved. But kindly see.
20.
Yes.
274. Kindly come to, I'll quickly run through the paragraph. Kindly come to
Yes,
49,
yes.
last sentence. Keeping this birth chart of virtual currencies in mind, let us now see how the petitioners are aggrieved by the impugned decisions, the grounds on which they challenge the same, and the justification sought to be provided by RBI. Over the page, 50.2. This is the submission, item 1, application of mind, satisfaction, relevant and irrelevant consideration. This is the submission. Now kindly come to paragraph 73. Page 323. Though the expression monetary policy is not defined in the Act, an entire chapter under the title Monetary Policy containing sections 45Z to 45ZO was inserted as chapter 3F. The provisions of this chapter are given overriding effect upon other provisions of the Act under section 45Z. Under section 45ZA1, the central government is empowered to determine the inflation target in terms of consumer price index once in 5 years in consultation with RBI. The policy rate required to achieve the inflation target is to be determined by a monetary policy committee constituted under section 45ZE. Now look at the RBI Act, madam. Chapter 3F, if there is the same book, madam, it will be around page 64 or so.
Yes.
Chapter 3F, monetary policy. The important sections are 45ZA. Central government shall determine the inflation target. They have determined it as 4 plus or minus 2. Then there's the Monetary Policy Committee. 45ZM, Monetary Policy Report. And 45ZN is the important section. Where the bank fails to meet the inflation target, it shall set out in a report to the central government the reasons for failure to achieve the inflation target, remedial actions, estimate of the time period within which the inflation target. For the first time, this power has been invoked, and RBI is in the process of submitting a report to the central government. Therefore, madam, monetary policy is concerned with inflation. Then kindly see paragraph 163. Mode of exercise of power. That takes us to the next question, whether the power is exercised properly in a manner prescribed by law.
Which paragraph?
163.
Just one second.
At
Yes,
page 366.
yes, we have.
That takes us to the next question, whether the power is exercised properly in a manner prescribed by law. Then kindly come down to placitum C. Satisfaction can be arrived at only by 1, gathering facts, 2, sifting relevant material from those which are irrelevant, and 3, forming an opinion about the cause and connection between relevant material and the decision proposed to be taken. In respect of each of these requirements, the learned counsel relied upon certain judicial precedents. Now, kindly come to paragraph 168. In fact, RBI cannot even be accused of not taking note of relevant considerations or taking into account irrelevant considerations. RBI has taken into account only those considerations which multinational bodies and regulators of various countries have taken into account. This can be seen even from the earliest press release dated 24/12 and is more elaborate than the impugned circular dated 6/4. The press release dated 24/12 states as follows. Then kindly come to 169. When a series of steps taken by a statutory authority over a period of 5 years disclose in detail what triggered their action, it is not possible to see the last of the orders in the series in isolation and conclude that the satisfaction arrived at by the authority is not reflected appropriately. In any case, pursuant on order passed by this court, RBI has given a detailed point-wise reply to the representations of the petitioners. In these representations, petitioners have highlighted all considerations that they thought as relevant. RBI has given its detailed responses. Therefore, the contention that there was no application of mind and relevant considerations were omitted loses its vigor in view of subsequent developments. Then, Millard, they say you must defer to the RBI. Now, kindly come to paragraph 191. I'm not disputing that your lordship will defer after looking into whether they have taken into account relevant considerations. 191. On the primary question. Now skip all that, Millard. Kindly come to the last 5 lines. In fact, even the learned counsel for the petitioners has ad item with counsel for RBI that economic regulations require due judicial deference. The actual argument of the learned counsel for the petitioners is that such deference may differ in degree from being very weak in respect of a decision of a statutory authority to being very strong in respect of a legislative enactment. Then kindly come to 193. The next ground of attack is on the basis of Article 19(1)(g), proportionality. Kindly come to 194. The parameters laid down in Mohammed Farooq are unimpeachable. While testing the validity of a law imposing a restriction on the carrying on of a business or profession, the court must, as formulated in Mohammed Farooq, attempt an evaluation, direct and immediate impact upon the fundamental rights. The larger public interest ought to be ensured in the light of objects ought to be achieved, the necessity to restrict citizens' freedom, the inherent pernicious nature of the act prohibited, the possibility of achieving the same by imposing a less drastic restraint. 195 is important. There can also be no quarrel with a proposition. Banking channels provide the lifeline of any business. This is especially so in the light of restrictions on cash transactions, etc., when currency itself has undergone a metamorphosis over the centuries, from stone to metal to paperless, and we've ushered into the digital age. Cashless transactions require banking channels. Therefore, the moment a person is deprived of the facility of operating a bank account, the lifeline of the trade of business is severed, resulting in the trade of business getting automatically shut down. Hence, the burden of showing that larger public interest warranted such a serious restriction bordering on prohibition is heavily on RBI. Now kindly come to paragraph 207. But nevertheless, the measure taken by the RBI should pass the test of proportionality, since the impugned circular has almost wiped out the BC exchanges. On a question of proportionality, learned counsel for the petitioner relies upon the 4-pronged test summed up in the opinion of the majority in modern dental. The 4 tests are: measure is designed for a proper purpose, measures are rationally connected, there are no alternative less invasive measures, and there is a proper relation between the importance of achieving the aim and the importance of limiting the right. Then kindly come to 211. The quotation from Lord Reed, next page, subpara 70. As I have mentioned, proportionality is also a concept applied by the European Court of Human Rights. I'm not reading the rest. Then 71. An assessment of proportionality inevitably involves a value judgment at a stage at which a balance has to be struck between the importance of the objective pursuit and the value of the right intruded upon. The principle does not, however, entitle the court simply to substitute their own assessment for that of the decision maker. I'm not even arguing that one. Then 212.4. In this case, the court concluded at page 387, singling out Bank Mellat, according to the court, was arbitrary and irrational and disproportionate to any contribution which it could rationally be expected to make to the direction's objective. So the decision itself was questioned as irrational. Now kindly come to 213. We cannot and need not go as far as the majority had gone on Bank Mellat. UK has a statute where standards of procedure for judicial review are set out and majority decisions in the application of those standards. But even by our own standards, we are obliged to see if there were less intrusive measures available and whether RBI has at least considered these alternatives. On the question of availability of alternatives, the July 2018 report is relied upon by Shri Sood. The relevant portion reads as follows. Kindly come to paragraph 224. It is no doubt true, page 397, that RBI has very wide powers, not only in view of the statutory scheme or the three enactments indicated earlier, but also in view of the special place and role it has in the economy of the country. Those powers can be exercised both in the form of preventive as well as curative measures. But the availability of power is different from the manner and extent in which can be exercised. Now, kindly note that sentence. Different from the manner in which it can be exercised and the extent to which it can be exercised. While we have recognized elsewhere in this order the power of RBI to take a preemptive action, we are testing in this part the order, the proportionality of such measure, for the determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entities, but there is none. When the consistent stand of RBI is that they have not banned the PCs, and when the government of India is unable to take a call, despite several committees coming up with several proposals, both of which advocated exactly opposite positions, it is not possible for us to hold the impugn measure is proportional. And 225 minutes, they, on the ground of proportionality, they set it aside. Now, apply the same test. Please look at the material. Please satisfy yourself that it was material relevant to demonetization at 86.4% of the crimes. I'm not even asking your lordships to look at the outcome of their action. More or less, Milan, I've heard the learned Attorney General say it twice, and the learned counsel for the RBI say it at least thrice. We may have failed in the objectives. But that is candor, and I appreciate that. But I'm not asking your lordship to judge by the outcome. I'm asking your lordships to judge at the time the decision was taken. If the decision was taken in good faith after taking into relevant consideration and eschewing irrelevant consideration and keeping the enormity of the action, that 86.4% of the currency will be withdrawn, then your lordships will uphold it. But if your lordships come to the conclusion, I don't find any material, and certainly the material does not seem to be relevant, and certainly the material does not have taken into account the enormity of the action, then your lordship will strike it down.